Conducting this hearing this morning at 10:05. This morning, I will be reading a letter from our Governor Healy. Dear councilors, I am pleased to nominate Karin Wilinsky to the position of Associate Justice of the Juvenile Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Sincerely, Governor Maura Healy. We have two witnesses today that will be speaking on behalf of Karin Wilinsky. We have Honorable Gloria Tan from Cambridge Juvenile Court and Attorney Thomas Fortgill. We'll ask Honorable Gloria Tan to come up and sit next to Karin. Floor is yours.
Good morning, counselors. It's nice to see some of you here again. It's my pleasure to be here before you speaking on behalf of Attorney Karin Wilinsky. I encouraged Attorney Wilinsky to apply to the juvenile court, and I was thrilled that she did, and even more thrilled when the governor announced her nomination. As some of you know, I was just before this body back in, I think it was November, when I was nominated to the appeals court. But at my hearing, I spoke about how important the juvenile court is. And that's why I think it's even a huge privilege to be here speaking on Attorney Wilinsky's behalf, because I know firsthand, having sat on the juvenile court for almost 12 years, what an essential, important job that is. And it's not a job for everyone, because we see very difficult, challenging cases, as you can all imagine. And so it takes a special kind of person to be on that court and to be able to do a good job. And that person is Attorney Wilinsky. I have known her since I sat on the bench, as I said, for almost 12 years. I would see her almost daily, some weeks, in the Cambridge Juvenile Court where I sat. And she was one of those attorneys, when she walked in on a case, you have this sense of relief as a judge, because you know that she's going to do a great job, and she's going to zealously advocate for her clients. And that's what you like to see as a judge, because it makes your job honestly easier. She has a great reputation, and I know you may not know most of the people here, but I do, because they're all attorneys. Most of them are all attorneys from the Middlesex County Juvenile Court Bar. And the fact that they're here, I think, is a testament to how well regarded Attorney Wilinsky is. She is somebody who has, I want to say, math is not my strong suit, but is almost 30 years of experience representing children and families in the juvenile court. So she knows exactly what issues the families face. And it can be, as I mentioned, a challenging job some days, because people are in the juvenile court not because they want to be, but because either they're desperate to seek help for their children, or as parents, they're experiencing difficulties in their lives, such as substance use, addiction, mental health issues, domestic violence, issues related to poverty. And so Attorney Wilinsky has had that experience representing some very difficult clients who I know, because I was involved in those cases, and knows exactly what they're experiencing and what the issues people face in that court. And sometimes the days can be a little bit chaotic, in the sense that, as I said, people are there. They're sometimes they're angry, they're sad. Sometimes it's the worst times of their lives, and things can get sometimes a little bit emotionally difficult. And it takes somebody who has a strong sense of themselves, and who can be able to assert, a calm demeanor. And I know that she will have a strong command of the courtroom, which is very important in that job. So I don't want to take up too much time, because I know that there is another witness and you want to ask Attorney Wilinsky questions, but thank you for the opportunities to speak on Attorney Wilinsky's behalf. I just do want to end with, even though I'm no longer on the juvenile court, it's my heart is always there. And I care very deeply about the juvenile court still. And as you all will see, I think you will see many nominees coming up because I still say we, but the juvenile court is going to experience a huge turnover. And I think, am I correct? I know Chief Gershengorn is here, maybe upwards to 10 vacancies in the span of 1 year coming up. So it's going to be a huge turnover, almost 25% of the court. And that's why it's even more important to have strong people like Attorney Wilinsky sitting on the court, given that turnover with respect to experience. So I'm happy to answer any questions you might have, and I strongly endorse and encourage you to vote for Attorney Wilinsky. Thank you for your time.
Thank you. Any questions, counselors? Thank you, Justice Tan. Now we're going to have Attorney Fortgill come forward.
Thank you.
Welcome.
Good morning, counselors. Thank you. It's a real honor to be here today. I've been after Attorney Wilinsky. She'll tell you probably for about 4 or 5 years now, suggesting that she apply for a judgeship, and probably to the point of badgering her, not just suggesting to her. I just think that she stands out amongst the bar as somebody who would be an excellent judge. She's very well respected, as you can see from just the folks that are here today. She's very thoughtful. That's one thing that really strikes out. One of the more important aspects, obviously, of being a judge is good judgment. I mean, obviously, and I think she's very good. She's very thoughtful, and she's very hardworking. She's a very skilled litigator. She knows the rules of evidence cold. She knows the rules of procedure. She will not need on-the-job training for this job. She's going to do an excellent job. I'm very confident. Judge Tan spoke very well about what's involved in the juvenile court, and it is true. It's a very difficult decision. I mean, juvenile court judges have to make really, really hard decisions, perhaps none harder than whether or not to terminate the parental rights of someone based on the fact that the children are subject to severe abuse and neglect. Those aren't easy decisions to make, obviously, and those have to be made with great care and great thought. And I'm positive that Attorney Wilinsky will do that. She's extremely well respected, and she respects everybody. I have been practicing with her over 25 years now, I think. So I think we've had several cases together. I think our most recent case took about 30 days or so. So I've seen her firsthand. I've seen her with clients. I've seen her with attorneys, with court personnel, with judges, with everybody. And everybody to a person has nothing but the utmost respect for her, because she gives respect and she listens, and she's very thoughtful, as I keep getting back to that point, and has good judgment. I think she'd be an excellent choice for the bench, and I would ask that you all support her. And I know I wholeheartedly support her and have been for quite some time now. If you have any questions, I'll be happy to answer them.
Questions, counselors?
Counsel,
Counsel?
how about demeanor with children, with the children involved?
Excellent. I've seen her with children. I've seen her with adults. I've seen her with grandparents. Excellent with children. Very good in talking to children and dealing with children. All across the age gamut. It doesn't really matter. She's great with everybody, because again, she listens. Like as I've said before, you can almost see the wheels turning in her head when she's thinking about something, and then she usually comes out with something really good that everyone's like, "Oh yeah, that's a great idea."
Thank you.
Any other questions, counselors? Thank you.
Thank you very much.
Is there anyone here in opposition of to this nomination, excuse me? Okay. Before we hear from the nominee, I would like to introduce my counselors here, starting with Counselor Maura Dorlin, Counselor Ianella.
Good morning.
Counselor Uni Sigler, and Counsel Paul DiPaolo. Attorney Karin? I open the floor to you.
Thank you. I just want to acknowledge the friends and colleagues and my wife, Deb Whitney, who are here today. We have 4 or 5 current or prior DCF lawyers. We have 5 or so private counsel. I have a couple of law school classmates. And I think I've covered everyone. So many of these people I've worked with for many years. Thank you to Governor Healy, Lieutenant Governor Driscoll, to Chief Counsel Paige Scott Reed, and Deputy Counsel Dara Kesselheim for ushering me through this process. Thank you to the JNC for their consideration, and to Valerie McCarthy and her team for seamless communication. And thank you, counselors, for inviting me here and hosting me in calls and meetings to consider my nomination. My parents and siblings guided me to where I am as an attorney and now as potentially a judge. My teammate in parenting my 2 kids, my wife Deb, and our boys offer a perspective on parenting and on teenagers that I certainly didn't have when I started out as an attorney. For my family's support, I am grateful. I was raised with an older brother and 3 younger sisters. All of them I keep close to me. All of them shaped me into who I am today. And maybe because of my close bonds with my sisters and brother, I have a deep commitment to the sibling groups in my caseload. Sibling relationships are essential connections. Separation from siblings is its own form of trauma that is often overlooked in the courts, as the focus is fundamentally on separation of children and parents. My parents raised me to care about people. My mother was a nurse. I was born in her hospital, St. Vincent's in the West Village of New York City. My mother was ever present as a scout leader, a class mom, head of the CCD for our parish, the mom who every kid knew and trusted. She was even the mom who pulled loose teeth out for neighborhood kids. My mom taught me empathy and compassion for others. I noted she was a non-paid hospice worker who was constantly there for family and friends who were sick, even at their deathbed. I noted that she walked the AIDS walk from early on, never afraid of those who were marginalized by a climate of fear. She was always a helper. My dad graduated from Brooklyn Tech High School at age 16 and left to attend Georgia Tech. After serving in the US Army, he went to Brooklyn Law School on the GI Bill and had a successful business career. He was there every step of the way, encouraging my choices. He taught me to be confident, open-minded, and to broaden my horizons. He passed in 2023, but he is here today with me. My parents raised us in a solid, loving environment. As expected, I began to realize that more as I got older. My college studies brought an understanding of the pain in many childhoods. Psychology and sociology classes led me to child development, but also to law and psychology. I thought I might teach kids, but I decided on law school. I went in knowing I would do something public interest minded. I should always have known it would be child and family specific. I had always loved working with children as a tutor, a counselor with the Special Olympics, as an active big sister in college, coaching high school kids through law school. A part-time writing position for CPCS is what led me to the juvenile court. Almost 30 years later, I have been blessed to call this court my practice home. Juvenile court is a team atmosphere, despite the often bitter battles on cases. My juvenile court judges recognize the challenges of clients and cases, and court officers are relied on to calm an emotional situation. Our probation officers often identify issues in foster homes or facilities before anyone else does, and the clerks set it all in motion. And I must acknowledge my many resilient clients who entrusted me with their cases. Juvenile court lawyers live these cases with clients and with each other. I'm going to give an example of this, but there are hundreds more. One trial involved a parent intentionally inflicting serious injuries, including burn. Everybody in that courtroom had to endure the difficult and draining testimony. Afterwards, the DCF lawyer reached out to all the lawyers to let us know that DCF has trauma resources in case we were interested. It's no wonder there is burnout in this practice area, and we rely on each other's shared knowledge in these cases to support each other and in turn to support our clients. Children in removal cases experience persistent trauma, often facing future hurdles such as delinquency or CRA cases. Parents in our court also carry layers of trauma with them. One thing I will never do as a judge, I will not dismiss the parties. It is urgent for parties to be heard. I have seen in my practice that clients who are heard, who we really listen to, are more likely to subscribe to what they need to do and more likely to establish the supportive relationships needed with professionals or probation officers or DCF or family members to overcome the path that led them into the court to begin with. So the CPCS writing job 30 years ago brought me to the juvenile court. The critical nature of the work kept me there. These cases are far-reaching, impacting a child's future, impacting the nuclear family, the extended family, and in a big picture view, society as a whole. These years in the juvenile court and my own steadfast commitment to child welfare has led me to sit in front of you, respectfully asking that you confirm my nomination to the juvenile court. I'll welcome any questions you may have.
Thank you, Attorney Karin. Any questions? Now we'll open up the floor to our counselors to ask you questions. We'll start off with Counselor Dolan.
Good morning, Attorney Wilinsky. It's really good to hear you this morning. I really appreciated your taking the time to speak with me and meet with me and get a chance to know you and learn more about your work. And I want to commend you again for the, I thought, really exceptional memorandum of law that you attached to your application. As someone who has done delinquency proceedings in juvenile court, but hasn't done care and protection cases, I really appreciated learning more about the law through those memoranda, but I also found them remarkably clear, remarkably persuasive. And though I know that with any memoranda of law, you never know what the outcome was, I thought they were inarguable. So I just really want to commend you for that. And as we talked about, because if I do have an area of expertise, this isn't it. I really appreciate the opportunity to learn more about the law, and I want to help educate the public about the law. One of the things we talked about is that because the juvenile court is rightfully not open to the public, what that means is that folks have no idea what's going on in our juvenile courts. So I asked you what you wanted folks to know, and you talked about something which I felt amounted to basically checks and balances, which I thought was really helpful. Could you share that with us?
So I appreciate this issue. I understand the interest in openness for courts in general. But on the other hand, the juvenile court specifically has really sensitive issues before it that involved trauma to children. Children have privacy rights, and we really want to work hard to not re-traumatize children and families. And so there is some oversight of the juvenile courts and of the juvenile court judges. That's in the form of appeals court, SJC, the OCA. So there is some, we discussed how there is some oversight, but I can appreciate both sides of this issue.
Mm-hmm. And we also talked about how, in addition to the public not knowing what's going on in our juvenile courts by necessity, there's also a lot of, I think, uncertainty about what DCF is doing. And you had mentioned relatively recent case law, which said that DCF has to make what the court called reasonable efforts to meet their plans. So I wanted to ask you, to what extent, just so folks know, to what extent the law allows judges to order DCF to do things, when you think that's appropriate and what your criteria is?
So judges have, broad discretion, and as a judge, I would take into account the legislation and case law that allows me to make orders of any kind, whether it involves DCF or not DCF. So, I mean, those tools are all in the kit for judges.
Okay. And we talked about the biggest issues that are happening in the juvenile courts, and you had mentioned lack of resources for clients. I was wondering if you could help just go over that with folks so that they have a better sense of what I saw in my own practice in juvenile court as really perhaps the most substantial challenge, which is under-resourced people who need help.
Right. So I appreciate that. That's a big issue in the juvenile court, and I'm sure in many other courts. Lack of available resources, and especially immediately available resources, is an issue that's near and dear to my heart and probably most of the people in this room. So I think it's important to always be searching for resources, and I'm sure as a judge, I would be communicating regularly with probation officers, and workers, social workers, through DCF lawyers, regarding resources that are available.
And last, I just want to ask you again, we had spoken about how my experience is that kids in juvenile court, and by the way, I think it's really important that we call them children. I don't really like the term juvenile court. I think juvenile can be a pejorative. Children's courts, the youth courts, but there they are, they're children. And they often don't really understand what's happening to them, though they will tell you that they do. And they often feel a lot of shame, a sense of self-blame, because they simply don't understand that their problems stem from not having enough support. What I believe the importance of making sure they have someone in an authority figure, especially a judge, is recognizing at that critical moment in their lives that they are not just terrible people, that there is good in them that deserves to be nurtured. Can you talk about what you will do as a judge to do that?
I think it's really important for judges to recognize the positives in cases and not just the negatives in cases. And so as a judge, I would communicate that. It would be important to me to be communicating to all the parties, regarding positives.
Thank you so much. I really appreciate that. You're welcome.
Thank you, Counselor.
Don't have any further questions.
Thank you, Counselor Dolan. Now we'll head to Counselor Tierney.
Well, thank you very much. Thank you. You know, one question I hear from so many people is when, and I do it too, we use terms that the people watching on TV or Zoom have no idea what we're talking about. You said DCF. People on Zoom have no idea what DCF is. Could you explain?
Department of Children and
I
Families.
understand, but I'm not saying.
Yes.
But for the people, and what is, I mean, I'm trying to make it for the people, DCF, LT, what does all that mean? So DCF, if you could just explain.
DCF is the Department of Children and Families. It's a state agency that is charged with safety around child welfare.
Just to make it easy, I do that, you know, a lot. Now you got an award, the American Jurisprudence Prize. Tell us about that.
So I was lucky enough to get into Judge Joseph Toro's trial advocacy course when I was in law school. Judge Toro was a federal court district judge here in Boston, and he was an amazing professor and person. I learned so much from him, and he really encouraged me to become a litigator. As part of that course, he gave out, there was an award for excellence in trial advocacy, and I was awarded that award.
Very nice. Your educational background is obviously outstanding. Dartmouth, BU Law, you can't do much better than that.
Yeah.
Good to see Judge Tan here today. How do you like the appeals court so far? I don't have any further questions. You have a very impressive resume, and when your name comes before the council next week, I'll be more than happy to support you.
Thank you, Counselor.
Thank you, Counselor Ferrera. I know, sorry. Counselor Ziegler.
Thank you. And thank you, Attorney Wilinsky, for being here. Thank you for taking the time to meet with me beforehand. I truly enjoyed our conversation. You know, in the conversation, I did ask you, you know, why now? And why the juvenile court? And you spoke to your, 30 years of experience, and how you truly feel like you understand the inner workings of the court, and you're looking forward to bring a lot of value to the court. You talk about care and protection cases being the most challenging cases that you face on a regular basis. I did ask you, how you would from the bench approach those types of cases and how you would reduce harm. Could you speak to that?
So I think as a judge in the juvenile court, it's important to listen. Everyone needs their voice in this court. And so I think the court runs in a much better way when the parties who come before it are given that opportunity. So as a judge, I would make sure I give that opportunity.
Also, in our conversation, in your questionnaire to the council, you talked about instances in which, violence or domestic violence was a factor within the case. And you go on to say in terms of cases where there's a section 58A dangerousness hearing or element to that case, that you seek to do things differently and essentially. Can you speak a little bit more to that?
I'm not sure what you're referring to in the questionnaire. In terms of dangerousness hearing specifically, I think it's important for judges, anytime they're considering taking away somebody's liberty, to act extremely diligently and carefully in their considerations, and that is what I would intend to do.
Which aligns with what you said. You said you would take strong consideration to the safety of the general public and make sure you're structuring your decisions around bail to reflect those conditions as well. I know this was a long time ago that you did this questionnaire, but I always, for me, it's important to have, follow-up conversations, especially with the public listening as well, to further dig into some of your stances.
Thank you, I appreciate it. Yeah.
The bench. And so, in your statements, you mentioned that you have a background in psychology and sociology. How would you apply the theories in which you've learned to the bench in order to create an experience within the courtroom that was beneficial to all parties?
Sure. I think that my studies, it's important for a judge to bring anything that they can, any resources that they have at their disposal. So that would include my studies, and it would include seminars that I've done, and I'm sure training that I'll be doing. It's important to bring that to the bench as part of the toolkit for a judge in making these monumental decisions for families and juveniles.
Thank you for that explanation. And so I did get a letter. I think all the counselors received a letter, and I promised that I would read it into the record. This is a letter of recommendation for your consideration as a nominee. It comes from Gabrielle Logian. She writes, I write in strong support of the nomination of Attorney Wilinsky to the Juvenile Court. I've known Attorney Wilinsky for over 15 years and can attest to the fact that she has the temperament, experience, and knowledge to be a first-rate judge on the juvenile court. As you can imagine, I may be considered a knowledgeable consumer of legal services, and I'm extremely cautious of the people who are charged to protect and represent my community. Not only have I myself been in private practice for 18 years, I've been on the bench for an additional 17 years. And these experiences have given me deep understanding of the attributes of a lawyer. Chief among these, in my view, are candor, trustworthiness, and sound judgment. It was based on these attributes that I entrusted my legal needs to Attorney Wilinsky. My trust was not misplaced. On every occasion and at every turn, Attorney Wilinsky demonstrated the knowledge of the law, attention to detail, sound advice, and reasonable approach that one would wish. Each time she did exactly the right amount of work at exactly the right moment in time. There is nothing left unattended to, and at the same time, she did not engage in unnecessary activities. Her advice was always practical and useful. Her counsel was sage. I have no doubt that the practical knowledge that comes from handling a large variety of legal matters for individual clients will serve Attorney Wilinsky well as a juvenile court judge. Her knowledge in that regard will be coupled with her experience over decades practicing in the juvenile court, representing both parents and children and acting as a guardian and as a guardian in that regard. I know commitment to taking on those cases in addition to perhaps more lucrative aspects of her practice. If she is appointed, she will combine legal knowledge with practicality and generosity of spirit in a unique way that is essential to the juvenile court judges. I have no doubt that she will be a terrific judge of that court and that the litigants who appear before her will be very well served indeed. And so if someone sends me a letter of recommendation for a nominee, I think it's important that it be heard by the public so that there's full transparency as to why you're sitting before us and why we are deliberating on whether or not you would be fit for the bench. Furthermore, in our conversations, I did, ask, what your intention was on the bench, and you explained in great detail how you look to bring your experience in order to improve, to expand resources, to ensure that there was a situation within your courtroom that people felt they felt listened to and they felt respected. One thing that you brought up that I thought was worthy of being stated in public is you mentioned that if there was an opportunity to come down from the bench and sit across the table with a youth individual before your court, that you would take that liberty as much as possible within the constraints of the courtroom. I found that to be, very remarkable because not many candidates would say that or would be willing to do that. So I do appreciate you sharing that with me and taking the time and for putting your name forward for this position.
Thank you, Counselor.
Thank you.
Thank you, Counselor. Counselor Kennedy?
Thank you. First of all, congratulations to you for your nomination.
Thank you, Counselor.
And congratulations to the Council of Civil for chairing her first hearing. I spoke with her about the 2 nominees she has today, and she was very supportive of your nomination when I talked to her yesterday. Couple of things. You're going to be a senior judge about a year from now, given the turnover that's about to happen in the juvenile court. I was going to do Chief Justice Gershengorn a favor by doing a motion to reconsider Judge Tiffany. But I was talked out of it. So anyway, couple of things that I don't do a lot of juvenile court work. I try not to because I get lost there. I don't understand all the rules and I'm too old to learn. But I did have a gun case not too long ago where it turned into a youthful offender case. And I was shocked to discover that when my client was detained, he didn't get credits for the youthful offender part of the sentence. Are you aware of that part of the statute?
So I'm somewhat aware of the delinquency statutes and the youthful offender statutes. I've been fortunate enough to focus in the care and protection realm.
I'm aware of that.
I was lucky to find that 30 years ago and really make it my specialty. So while I've had overlap in juvenile court on clients in a variety of cases, whether they be care and protection cases, children requiring assistance cases, delinquencies, and I understand the general workings of those. My expertise for my clients has been in the care and protection realm.
I understand that. We talked about that a couple of times on the phone over the last month or so. That primarily what you've done most of your career has been care and protection. How are you going to get up to speed on the delinquencies?
I'm a quick study, and I look forward to taking on delinquencies and anything else that comes before me in the juvenile court.
One of the problems with being a quick study in juvenile court is you're on your own in that courtroom. The public's not there. You're there. The other judges aren't in the room. Generally, other lawyers aren't in the room. What are you going to do? You're going to be sitting there. You're going to be sitting in delinquency cases a lot. Probably the first month.
Mm-hmm.
What have you been doing to get up to speed?
I've been reading. I read statutes. I've been reading MCLE volumes, and I anticipate I'll be getting trained as well.
Have you been to a DYS facility?
I have been to a DYS facility many years ago, and I've been to many jails.
When did you go there?
I had a client in a DYS facility probably 15, 20 years ago.
So it's been
It's been
quite a
for a
while.
while, and yes,
And to go look at them?
As a judge, I think it's important to see where clients are, where parties are
We
living.
call them DYS facilities, but they're jails. And we're sending kids to jails. And, you know, that should be a very rare event, in my opinion. Extremely rare, only when they represent a significant danger. Anyway, we talked on the phone before the holidays, and we talked the other day quite a bit. You've answered all my questions. I think, I do think you're gonna get up to speed pretty quickly. I think you're gonna be a great judge. And I said you're gonna be a senior judge soon with the turnover. Chief Justice Gershon's gonna have quite a bit of training to do with everybody coming in. She does a great job, as I had cases with her about 4 decades ago. She was 12. I certainly appeared in front of her mother many times, both in district court and Superior Court. She was a judge too. So you're gonna have a good mentor and trainer there, and I hope you listen to what she has to say. I'm sure you can always pick up the phone and call Judge Tan if you get lost. I don't have any other questions. Thank you.
Thank you, Counselor.
Thank you, Counselor. Counselor DiPaolo?
Thank you. Good morning.
Okay.
Thank you, or congratulations on your nomination. Thank you to the impressive crew you have here as witnesses and as supporters in the room to affirm your qualifications for the bench. In your application, one of the questions that's asked is, what's the greatest challenge confronting the court that you're going to? And we know there's going to be a lot of turnover. And you talked about unevenness, which I think a lot of courts would sympathize with, but the fact that depending on obviously the judge, but beyond that, the ADA, the DCF worker, all the different players that come into play. And depending on where you land, you might end up with different outcomes. So, and you talked about some of the things you'd like to do to improve that unevenness. One thing you talked about was sticking to time standards and forcing movement on cases. And 2 questions around that. Number one, just so I can hear you articulate your view on children's experiences in the system. What are the consequences, the practical, actual consequences for children when cases end up delayed for reasons that might be beyond the court's control, but what are some of the practical consequences on children?
Well, there's different kinds of cases that come before the juvenile court. So delays and delinquencies would mean potentially delays in if a juvenile is locked up pretrial, so pretrial detention, it could mean a longer lockup period. On the other hand, a delayed trial could mean a delinquent not having to go to a DYS facility or other repercussions. In the CNP or care and protection realm, delays can be helpful for child clients, and they can hurt child clients. It really depends on the facts of the case.
And
delays mean children are going to be returned home.
And we know how all our courts and the juvenile courts are strained on resources. How will you as a judge try to force movement on cases? Or how do you imagine that being an effective, something you can effectuate?
As a judge in the juvenile court, I think it's important that everybody communicate on the status of cases and the future progress of cases. And so as a judge, I would expect that I would be sort of leading the charge on that communication in what's expected going forward in a case.
And, you know, as I referenced and you affirmed, different DCF workers, different folks who interact on a case. Do you think it's important? Has most of your juvenile practice been in Middlesex? Is that correct?
The majority has been in Middlesex.
And do you think it's important when, including as a potential judge, but as a practitioner, that you have the knowledge of the community-based resources that are available, like the local resources that could potentially be helpful in an adjudication or, helpful to a client?
Sure. I think that judges and practitioners working in juvenile court are constantly communicating with each other, with DCF, with the Department of Children and Family Workers, with probation officers, around resources and particularly available resources. And so I would expect as a judge, I would be continuing those communications.
Because it's kind of like a team in the courthouse, right? Like the DCF staff in the region tends to be there and the probation officers and, right? I mean, it's kind of a
Yes.
team effort. And so to me, it seems like there's a lot of value to having being part of those teams in each local region,
Yes, agreed.
CRAs, you've dealt with some CRAs.
Correct.
And I'm wondering, conditions placed on CRAs. When we think about unevenness, have you ever seen in your years of practice conditions that you thought were counterproductive to a child's well-being or a child's ability to find their way out of the system?
I think in my 30 years, I've seen my fair share of everything on these cases. And so, yes, I'm sure I've seen situations where minors are given conditions that are difficult for them. I'm particularly sensitive to that when I've represented them. And parents are also given conditions that are difficult for them.
And sticking with the CRAs, when you've seen difficult conditions, have you ever had a client where you saw a condition that you knew would be violated? Or that you knew there was a very, very substantial likelihood of it being violated?
I think as practitioners, we're not acting on behalf of our clients. So I can't say that I've ever seen a condition that I'm certain a client would violate, because the hope is that the clients are subscribing to what's going on in the court. And if a condition is placed on them that's aimed at trying to help the situation that they're in, the hope is that they'll abide by the condition.
Well, I mean, so I heard DUIS facilities mentioned. Have you visited DCF facilities and group homes?
Yes.
And so you know what life is like in group homes. It's
Yes.
difficult for the children.
It is.
In my experience working with children who appear in the court as CRAs, which is not as an attorney, but as an educator, I've seen a lot of conditions put on kids that I don't think are advantageous, because I know they're going to be back in 6 weeks and I know they're going to have violated, and it's going to depend on who they land, who that team is, as to what the outcome on that is going to be. You know about trauma, you know about the challenges families face. When you think about brain development, how does that come into play to craft conditions on a CRA, for example?
So I know the brain science and case law does tell us that the brain of a teenager is still developing. And that would be a topic that I would take into consideration in structuring any conditions.
What are the consequences of instability in a child's schooling? You had experience to witness that.
Yes.
Disruptions, bounces in districts, et cetera.
Of course, disruptions in stability for children can often result in children not attending school and dropping out eventually.
Which I've seen as conditions placed on children, their attendance at school. Is that
Is that
is that unusual, or is that typical?
It's in some circumstances, it is part of their conditions to attend school. I think the goal being to try to find the best match for them. Sometimes it's not a traditional school.
I have no further questions, Counselor. Thank you.
Thank you.
You, Counselor? Yes.
Just to interrupt 1 second. No one in this room, I'd say a lot of people in this room have no idea what CRA is. I've texted 5 people.
Wow, you didn't text me, did you?
No, I know. Hold on, the reason I didn't text you. speaking, I didn't want to interrupt. So these terms, we have to be more careful. You can laugh, that's fine, but most of the people don't know what a CRA is. So if you could explain what is a CRA? I don't know what it is. And I'm not the only counselor who doesn't know what a CRA is. What is it?
Thank you, Counselor. I don't mean to take for granted that this particular audience would be interested in the juvenile court, but a CRA is a child requiring assistance. So it used to be known as CHINS, which a lot of people recognize. So CRA could end up in the court from a referral that could come from family, school, and typically, well, I should let the nominees speak, but there's a 72-hour hearing. Is that correct?
72-hour hearings are in Karen.
I'm sorry, Karen, protection cases. Yeah.
Yeah, no, that's what I appreciate. Again, like I said earlier, there's people on Zoom, no idea what these terms mean.
Thank you, Counselor.
Thank you.
Thank you, Counselor. You read my mind. Congratulations, Attorney Karen, for your nomination. And I had the pleasure of meeting you and knowing that you are very passionate working with juveniles and their families. One of the things that stuck with me is when we were talking about the importance of keeping siblings together, especially when you're dealing with a particular case where a child has to be removed from the home. Do you mind elaborating that for us here for this hearing?
So in general, the sibling separation cases are heartbreaking. And again, there are a lot of practitioners here and on both sides of it. And I think that it is a hard issue within the system.
Thank you. And for the last couple of weeks, we've been hearing a lot about gun violence against teens or teens being involved in gun violence. I know there was a teen that was shot in the face in Easton, Massachusetts. Also, there was 4 teens that were charged in connection in a shooting in Brookline. My question would be, what factors do you consider when assessing a juvenile's vulnerability to violence?
I think it's important for judges in the juvenile court to take into consideration that everyone coming before them brings their life circumstances. And it's really important to recognize that when you're hearing the cases. I would anticipate I would do that in gun cases.
And my other question would be, how do you assess the impact of juvenile homes, social environment on the behaviors and risk factors for violence?
As a judge, it's important again to take into consideration the life circumstances of the people who come before you, and that includes children and their histories and where they lived and who they've lived with and what they've experienced.
Thank you. And I know that you've been practicing for more than 30 years. We had a conversation as to throughout your practicing law, you know, you weren't always right. You weren't always aware of the impact of mental health. I would say that for everyone. You know, within COVID, the mental health has been the #1 top priority for everyone, and identifying the signs. What can you say about being in the courtroom and you have a juvenile or a parent that is belligerent, speaking out, and clearly have a sign of something is up, or they're not on their medication, or mental health is an issue? What would you do to put order in the court?
Judges have a lot of options at their disposal. One option is to take a break. Sometimes it's as simple as someone appearing before a judge needs a break from the courtroom. So I would take that into consideration.
Thank you. I have no further questions.
Thank you.
Any other questions, counselors?
Good job.
Thank you. Hearing is adjourned.
Thank you.
Conducting this hearing this afternoon. It is 1:38 and this meeting has started. I have a letter from the Governor Maura Healey that I will read. Dear councilors, I am pleased to nominate Tiffany Ellis-Niles to the position of Associate Justice of the Juvenile Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth. Sincerely, Governor Maura Healey. This afternoon, we have two witnesses speaking on behalf of the behalf of Attorney Ellis-Niles. We have Honorable Joseph Johnson, as well as Attorney Andrea Park-Lyles. We call Honorable Johnson to the floor.
Thank you. Good afternoon.
Good afternoon.
Sit.
Yes, absolutely.
My name is Joe Johnston. I'm a juvenile court judge. I am the first justice of Norfolk County Juvenile Court. I just started my 25th year as a juvenile court judge. And me to be sitting next to this nominee, it's truly a privilege and an honor. Be sitting before this council in support of Tiffany Ellis-Niles. I'd like to commend the governor, the lieutenant governor, and their legal staff for nominating such really a gifted and talented attorney to the juvenile court bench. I've known Attorney Tiffany Ellis-Niles for over 10 years. I think I started practicing in the Suffolk Juvenile Court when I was an attorney, when I was a judge in the Suffolk County Juvenile Court with my dear friend, retired Justice Liz Harris. And then more recently, the first justice in Norfolk County. I think as so many of the councilors know here that the cases that we hear in the juvenile court are some of the most difficult, gut-wrenching, and emotional cases that you'll ever see. Cases of child abuse, child neglect, serious delinquency and youthful offender cases, children requiring assistance cases. These case types all require a judge's utmost care, deliberation, and attention. I presided over many, many cases in which Attorney Ellis-Niles has represented a party in one of those difficult, gut-wrenching cases. He is so impressed me and the other judges that I have the privilege of serving with, the knowledge of the law, for a zealous representation of our clients, cool, calm, and respectful demeanor during these highly contested and emotional cases. Notwithstanding her zealous advocacy for her clients at all times, Attorney Ellis-Niles exhibited nothing but respect for opposing counsel to the court. The mission of the juvenile court is to protect our children from abuse and neglect, promote opportunities for children to live in safe, stable, permanent family environments, to strengthen and support families and the children that needed help, to rehabilitate juveniles and support in every way possible in areas such as their education, substance misuse, mental health challenges, and all the while, do everything we can to keep our community safe. Many of us that work in the juvenile court believe that it's the most important court on the planet because the work that we do and the people we work with in the juvenile court have such a profound impact on the youth and families for generations to come. If confirmed by this council, I'm absolutely certain Judge Ellis-Niles will be an exceptional juvenile court judge. He will treat all those that appear before her with dignity and respect. There will be no more important case than the one in front of Judge Tiffany Ellis-Niles at that moment in time. Judge Ellis-Niles will without question dispense her responsibility with compassion and the highest degree of intellect. And in closing, I respectfully urge this council to confirm Attorney Ellis-Niles the juvenile court bench. Thank you for this opportunity.
Thank you, Honorable Johnson. Counsel, do you have any questions?
I mean,
Sure.
you're not off the hook yet, Judge. You almost made it.
You said brevity, so I tried.
When you talked about the mission of the juvenile court, I agree with everything you said, but you left part of it out. You didn't talk about the delinquencies. You talk about the children that needed help, the families that needed help. But I have a little issue with the juvenile court in terms of, I don't spend a lot of time there. I very rarely get into juvenile court. Frankly, my practice is elsewhere. But one of the concerns I have is we lock a lot of kids up, either with 58As, youthful offenders. The fact that they happen to be youthful offenders doesn't mean they're not children, and they still are. Tell me what your philosophy is in terms of that. When do you see it the appropriate time, either pre-trial or after a sentence, to lock somebody up?
Oh, not an easy question to answer.
Because it's still a jail, even though it's a UIS facility, it's still a jail.
So as we know, with youthful offender cases, the statute is such is that the sentencing judge, if you will, if it gets to that point in disposition, has options. So one of the options is that we could have the youth remain in the community on probation, supervised by probation. In fact, I'm joined here with me, Chief Probation Officer Bibier, who's really an expert in this. So his team has the discretion well, if given an order of probation, to allow a youth to be on probation, supervised probation as a youthful offender. And to your point, Counselor, is that, you know, obviously there is also the option of youth services. If you look at the statistics now, the numbers of those youth that are detained pre-trial are significantly lower than they were years ago. The number of commitments to the Department of Youth Services.
I don't see that, Judge. I don't, like I said, I don't put no quarter officer. But I did go, the last couple of years, I was in Lynn. And I went into the lockup to see my client. And there had to be 6 or 7 children in jail cells there. It kind of shocked me, to tell you the truth, that we're locking young kids up.
I'm surprised to hear that, because I know when I sat in Lynn for a couple of years, several years ago, and the Lynn Juvenile Court sits in a different location than the district court.
Oh, no, I know where it is.
So I guess the point I'm making is that youth that could have been detained in the juvenile court would have been in a separate. But I just generally speak to you that, and I see it just from where I work in Norfolk County, I'm generally in the Dedham profession. The number of youth that are detained is significantly lower, The numbers from before. I happened to be in Quincy Court yesterday, and there was one youth that was in detention after a real busy list, and he did not return to detention. He was released. So I did try to address delinquencies, and forgive me if
I appreciate your answer. My impression of what I've seen is a little different, but I do appreciate. Now, I would have a suggestion. I'd run before you get another question. Excuse me, man.
Any other questions?
I just want to say thank you for your service. Incredible. You've done 25 years. I do think it's like one of the you made to the juvenile court, affecting lives of children. I did speak to a Bristol County juvenile court judge who wasn't familiar with the nominee at all. So does she practice a lot before you in Norfolk, or?
So my experience with Attorney Tiffany Ellis-Niles is when I was in Suffolk, when she had some cases there, and then 5.5 years ago I was assigned as the first justice in Norfolk County, and so I've had the experience of a number of cases with her over those years in Norfolk County Juvenile Court. I don't know. I would say it's probably not her primary court, but it's a court that she did.
Bristol not primary?
I'm in Norfolk County, and I'm saying.
Right. Did you see her regularly?
I saw her fairly regularly over those 5.5 years, and then, as I said, when I was in Suffolk.
Right. I appreciate you being here today and appreciate your service.
I appreciate the time. Thank you so much. Thank you. Thank you, councilors.
Any other questions? Thank you. I'm gonna call Attorney Ellis-Niles to come up.
Good afternoon. My name is Adrena Ellis-Niles, and honorable chairs and distinguished members of the committee. I've known Tiffany for over 24 years now, and I'm just gonna read because I don't want to forget anything, and I want to make sure I say everything that I need to say in honor of Tiffany here today. I want to thank you all for the opportunity to speak today in support of my dear friend and partner, Tiffany Ellis-Niles, as she seeks confirmation for a judgeship. I had the privilege of working alongside Tiffany for over 15 years. And in that time, I have witnessed firsthand her remarkable integrity, intelligence, and unwavering commitment and fairness in both our professional and personal interactions. Tiffany has consistently demonstrated the qualities that define an outstanding judge: sound judgment, empathy, and an unyielding dedication to justice. She has a keen understanding of the law and an ability to apply it impartially, ensuring that all parties involved in any matter before her are treated with respect and fairness. What stands out most to me is her deep sense of responsibility, not only as a legal professional, but as a person. She possesses a rare ability to listen attentively, thoroughly considering each perspective before reaching a conclusion. This is a quality that will undoubtedly serve her well in the judiciary, where every decision impacts the lives of others. I have known Tiffany for over 24 plus years. We met and attended law school together. We had children at the same time in law school, at the point our law school babies. And Tiffany and I established a law practice 15 years ago, actually this month. And I could not have asked for a better friend to have partnered with. Although this is bittersweet for me, because I'm losing a wonderful partner and business associate, I am beyond honored to be here today to speak on Tiffany's behalf because she is more than deserving of a judgeship, in my opinion. I have no doubt that Tiffany Ellis-Niles will bring the same diligence, professionalism, and ethical standards to the bench that she has shown throughout our time working together. She is more than deserving of this honor, and I wholeheartedly support her nomination. And I look forward to calling her Judge Ellis-Niles in the future, even though I'm gonna call on her as my cabinet, as we call it, when we need advice on certain cases. We have staff meetings, just the two of us and our paralegal, but I'm gonna miss her in the office. I'm gonna miss her sharing in the expenses of our partnership. But I'm really proud of her. I'm really happy for her. And I'm honored to be here on her behalf. And thank you for your time.
Questions, Counselor?
Am I remembering correctly that you met at orientation at law school?
We did. That was in 2000.
It's an interesting story. It's really great I've heard about you, so it's great to see you, and I really appreciate your testimony today.
Thank you. Thank you.
Any other questions?
Thank you.
Thank you. Is there anyone here in opposition to the nomination, excuse me? Before we hear from the nominee, we'll start from my right. We have Counselor Maura Dolan. We have Counselor Eunice Ziegler. We have Counselor Terrence Kennedy. We have Counselor Paul DiPaolo. We have Counselor Tara Jacobs. And we have Counsel Joseph Barrera with us, and myself, Tamisha Civil. I know you have a lot of support here today on your behalf, friends and family. Would you like to acknowledge them?
Sure, since they made the trip. I will start over here. I have the Honorable Maura Hardiman. You've already met, but the Honorable Joseph Johnson, the Honorable Leslie Harris, my partner Adrena Parkman-Lyles, my good friend Regina Hunter, my friend and colleague Reggie Revere. Now go to the side. My friend and colleague, and now the president of the Massachusetts Black Lawyers Association, Ivana Epperson Temple, the chief, Honorable Dina Gershengorn, and April English, of course, legal counsel, but they had to be here anyway. So that's everyone. Thank you. Have the floor. Thank you. Well, good afternoon. I want to begin by expressing my deepest gratitude to Governor Healy for this nomination to the Juvenile Court. I also want to extend a heartfelt thanks to Lieutenant Governor Driscoll, the Governor's Council, Paige Scott-Reed, and Dara Kalsenheim, as well as the Judicial Nominating Committee and Valerie McCarthy and her staff, and of course, the lovely Miss Joyce, who's always very pleasant when I come to this building. I want to thank everyone for their support throughout the process. I want to thank Madam Chairwoman, Counselor Civil, for presiding over this hearing, and all of the counselors that took the time to speak with me or meet with me in person in preparation for this hearing. Your dedication to the process ensures the integrity of our judiciary, and I am honored to be before you today. I want to thank again my family and friends and colleagues, the ones present and the ones watching at home, for their unwavering encouragement, which has been very humbling and inspiring. Finally, I want to express my gratitude to my two witnesses, the Honorable Joseph Johnston and my friend and partner, Adrena Parkman-Lyles, for their presence and support today. This moment right now is very profound to me, and I am happy to share a bit of my journey with you. I was born in Boston and I spent the early years in Dorchester before moving to Jamaica Plain during high school. My parents are both from North Carolina. They divorced when I was in elementary school. But despite their separation, my father, Charles, remained a constant source of support then and now, while my mother, Phyllis, worked full-time to raise me and my two siblings. She instilled in us the values of responsibility, resilience, and community. Just last month, after decades of hard work, she retired from K&L Gates as a legal coordinator, leaving behind a legacy of determination, which inspires me to this day. Growing up, my siblings and I were often home alone after school, but my mother's strict rules ensured our safety and accountability. We had to call her at exactly 2 p.m. every day, no exceptions. We didn't know it at the time, but our neighbors were her eyes and ears, reinforcing a sense of community that kept us safe. She created a village around us, and that sense of shared responsibility became a value I carried forward into my professional life. In high school, I wasn't a straight A student, but I worked hard enough to stay out of trouble and off of Phyllis's radar. That changed when my guidance counselor told me and my best friend that we were unlikely to attend college based on our grades and our activities. This lit a fire in me, and both me and my best friend worked tirelessly to improve our grades, becoming class officers and joining nearly every club that we could. My graduation, we had both got accepted to UMass Amherst, which is a testament to our determination and support. I attended UMass Amherst, initially planning to study pre-law, because like many young Black girls inspired by Claire Huxtable, I dreamed of becoming a lawyer. However, I was encouraged to explore other fields, as when I was going to attend law school, I was just going to learn the law anew. So I chose psychology, intrigued by understanding how people think and behave. During my second year of college, I learned that I was pregnant with my first child. Focused on completing my education, I planned my semester carefully. My son, ever considerate, was born during the winter break, allowing me to have time off to spend and care for him, while transferring to UMass Boston to be closer to his father and family. And with my family's support, I graduated in 1999, making the dean's list, all while balancing school and motherhood. The following year, I began law school, attending part-time at night while working full-time as an outreach worker, advocating for the families and children who lived in the community that I grew up in. My second son, not so concerned with my schedule, arrived on my constitutional law final, which to his credit was his actual due date. Once again, with unwavering family support, I graduated in 2004. While my legal career was not entirely linear, it was my return to working with the youth and family that inspired me the most. Upon completing my certification with the Committee for Public Counsel, I joined the private bar to represent families in care and protection cases. This work became my passion. I represented parents and children in some of the most challenging circumstances, including termination of parental rights and children requiring assistance, CRAs. I visited clients literally, where they were, either in foster homes, group homes, DYS facilities, and I advocated for their access to services, mental health support, and opportunities to thrive. Having been on the Children and Family panel for nearly 16 years, I've had the opportunity to represent families in some of the most heart-wrenching moments. But there's one case in particular which involved a mother who had lost parental rights to her children as she struggled with substance abuse. Many believe she couldn't succeed in maintaining custody of the child at issue when I was assigned to her case. However, juvenile law teaches us that unfitness for one child doesn't automatically determine unfitness for another. Determined to give her a chance, I drove her to Brewster, Massachusetts, where she entered a residential program. She worked hard to address the underlying issues that plagued her for so long. And with my support and the support of others, she completed the program, she regained custody of her child, and she proved that with support, advocacy, and perseverance, people can rewrite their stories. She reached out to me just 2 years ago, and both her and her son are still doing well. My family's experiences have also shaped my perspective on justice and fairness. My younger brother was deeply affected by the criminal justice system, receiving an excessive sentence for his poor decisions. His experience reminded me of the disparities within the system and reinforced my belief that every individual deserves dignity, fairness, and compassion. In addition to my legal work, I've held leadership roles as president of the Massachusetts Black Lawyers Association and the Massachusetts Black Women's Attorneys. These roles strengthen my ability to collaborate, lead, and navigate complex challenges, skills I believe are essential for a judge in the juvenile court. If confirmed as a justice on the juvenile court, I will bring these lived and professional experiences to the bench. I'm committed to ensuring that every individual, especially every child, is treated with dignity, respect, and that decisions are made with fairness and empathy. I will work tirelessly to ensure children and families receive the support they need to move forward and thrive. Thank you for considering my nomination. I respectfully ask for your vote, and I look forward to answering any questions you have. Thank you.
We will now open the floor to our counselors. We'll start with Counselor Dolan.
Thank you so much. I have to say, Attorney Ellis-Niles, I was a single mother-in-law, so it was very challenging, but my goodness, I didn't have a baby in the middle of it. So good for you, very impressive, and really representative of your career, frankly, that you managed all of that as well as you did. I know that the bulk of your experience in juvenile court has been with care and protection cases, so I wanted to ask you about those and talk about, I was going to say, two of the most important things, but everything in juvenile court is profoundly important. Everything has enormous impact. But I did want to ask you about removal and reunification. And I appreciated the time that you spent speaking with me and talking about these issues. And I asked you quite plainly if you thought that there was a bias in favor of removal. Can you tell us about that, whether you think there is one, and how you would address that as a judge?
Well, every case that, comes before the juvenile court, is, it can be challenging, just, depending on, what's going on, behind the scenes and all the information that we're given. When you talk about biases, I mean, we all have them. But I know that we try to not make, assumptions. We try to get all of the information, at least I do in my practice and some of the colleagues I work with. If I was a judge dealing with, concerns regarding bias for removal over just children all the time, do you mean, or?
Just generally.
Yeah, I mean, it just.
Do people err on do you think that courts are erring on the side of removal?
Well, it really depends. It depends on, the circumstances. I think that, the courts take a careful look at the whole picture when emergencies come in to ensure that, what's going on at that time before just jumping, to removal. I think those are considerations that are made that they need to be made because every case is different, depending on the circumstances.
It is. And so of course there's a legal standard and then there are also your own individual standards. So what are the criteria that you will look at as a judge in making these kinds of decisions?
Thank you. I mean, I would follow the law, I would, base the decisions, that are before me on the law and then also the facts and, what accommodations are before me that have been made before removal became necessary.
And on the other side with reunification, what do you look for when you're making a decision? What will you be looking for when you're making a decision to reunify?
Yes, I would be looking, to do that thoughtfully, taking time, making sure that the reason why the removal was done in the first place has been adequately addressed, with all of the, the social workers, probation, collaborating with us to serve in place. I know in where I practice, it's not a rush to just place children back. I want to make sure that those underlying issues have been resolved so that, a child is not brought back into the system and has to be removed again.
You also said you wanted to see, I believe you said you wanted to see more conditional custodies. Can you talk about what that means, conditional looks like, and how you would do that as a judge?
Yeah, so conditional custody is when a case comes in on, a 72-hour hearing or an emergency and, parents opt to have a hearing, just hearing from the testimony, hearing from, their providers or stakeholders, who's ever involved with the family, just hearing what's going on with that family, what's in place to safeguard the children. Are there eyes on the children? Are the children seen in the community daily? Are there mechanisms that can allow a child to stay home and not be removed as, necessarily, because this is a court that thinks about the best interests, of the children, and removing a child from a home has to be done, considerately. You have to think about, now this child is going to be placed, with strangers. Is that really in their best interest? What's going on in the home? Is there an immediate need for the child to be removed? Are they at risk for harm, physical harm, even emotional harm? If we can, get a better understanding on that, and be sure that they can be safe with supports in place, then we can look more to conditional custodies.
I just have one more question for you, which is another thing that we talked about, which is the requirement to find kinship placement when possible. And you spoke very plainly about the pros and cons of that and how that works. Can you share that with us today?
When we talked about it, I mean, in a perfect world, I wish that we could keep the children, at home and then remove the parents and put them in foster care. But that's not, what we can do, and then find other kinship placements to come in and support the children. But I do know, in my practice, for many years, that we do look for kinship placements first. We ask those questions. Those questions are asked either by the attorneys or by the social workers or probation to see if there are family members that can take the kids in rather than, place them in foster homes.
Thank you. I appreciate all your thoughtful answers, and your work is very impressive. And just a shout out to another lawyer who was a liberal arts major. That's the way to go.
Thank you.
Thank you, Counselor. Counselor Ziegler.
And thank you, Attorney Niles, for being present today, and congratulations on your nomination being before us today. So we had an opportunity to have a conversation prior to this hearing, and I appreciated the conversation that we had and being able to get to know you a little bit more. Several things stuck out to me in our conversation. The fact that I've, worked in family law, and you explain it as an intersection between family law and juvenile law. I know we talked in depth too about your educational experience and your majoring in psychology, and I wanted to delve into that a little bit more and ask how you would apply some of the theories that you learned in psychology to the bench should you be approved.
Yeah, so I mean, again, studying psychology, because, I was interested in like the behavioral parts of it and, why people do, what they do. I mean, I think that's important for the work that I've done in family law as well, especially in, juvenile court, dealing with families and children, who are faced with neglect and all sorts of issues that we don't see. So applying that, it's just getting all of the information and making sure that, I'm talking, to the right, or getting the right information is being gathered for me to be able to see what's really going on, checking back in, if someone comes in and, they're experienced some type of trauma or neglect, just seeing what was going on with that person or that family, 6 months prior, to try to get an understanding of the behavior to be able to put the right, services in place.
And so, a lot of the individuals that will be coming before you, trauma will be a large factor. But you mentioned in our prior conversation that your primary goal would be to keep the family intact where it's possible. Can you speak more to what strategies or initiatives that you employ?
Sure, again, depending on, the background, and the circumstances and the overall goal of the juvenile court is to keep families in. So, again, I think that's done with collaboration and, working with, community stakeholders, leaders, social workers, probation officers, to make sure that we're providing families with access to services so that they can thrive and stay together and, fix the underlying issue that brought them before the court.
One of the areas that you indicated about that you had not had much experience in is the delinquency piece of the court. Can you speak to how you would look to expand your expertise in that area?
Sure, yes, and when we talked about that, it's more of, the experience of not representing juveniles, particularly in that session, but I have participated on the delinquency side. That's why I met some of the youth that I work with on my caseload when I was a caseworker. And also with care and protections, I do have, clients who, because of the stress of the care and protection, they, they make some poor decisions. So, I mean, to get, I love learning, to get up to speed, I think we should stay, I can talk to my colleagues, there's trainings, there's CLEs, there's just always ongoing training that you can have to make sure that, you're aware of any nuances and, you're following along with that side with delinquency.
And so, in the court, no one day is the same. And all the needs of folks who are coming before you will be varied. We learned since COVID that you can be flexible in the courts with the invention of incorporating Zoom and other virtual platforms. Can you speak to a situation in which you would be amenable to using a virtual platform versus an in-person hearing?
Yes, I mean, like you said, COVID taught us, to be flexible and that there are other options. I mean, when we're dealing with, matters that are not evidentiary, where you have to, see someone personally, observe their demeanor and assess their credibility, to keep, things efficient, it's, simple motions, administrative motions. I can see that as a means to just use Zoom, just to keep things efficient and, to keep the docket not clogged.
So, a lot of your experience you have a lot of experience in the care and protection piece. And that tends to be a large challenge for the juvenile court. We talked about that a little bit as well. Can you speak to what research and or studies you would be looking to rely on as you try to ensure that these cases are run smoothly?
Sure. I mean, just the overall, making sure we're, at the forefront is the best interest of the child. So, I mean, that's something that, I would, and I believe my colleagues keep at the forefront, and just making sure that, we're following that and we are, doing our best practices and, getting the information that we need from the people that we're relying on that are before us, either that's the attorneys or the social workers or probation officers. And as far as, like research, I mean, looking up the case law, making sure we're following it, and if any new case law is coming out, making sure that, we're referencing that or using that to rely on when necessary or when appropriate.
So, should you take on the bench, the decisions that come down from you can have a large impact on the lives of youth that come before you. You talked a little bit about your community-oriented focus and how you would intend to balance community service and volunteering along with your judicial duties. Can you speak a little bit to that and why you feel that's important?
Yes, I mean, I feel it's important to, be in touch and stay in touch, with your community, especially the community that, you're serving in and where your families and children are coming from, because being, in touch with that and having, collaborations when you need services for a particular family or situation, you have that information, and it's helpful because when, like you said, the courts are, clogged with people coming in with all sorts of different issues, no cases is the same. But if you are involved in the community, then you have, at least a resource and immediate access to services that you can immediately, connect a family with. So I think that's important to keep that connection.
Thank you. I definitely appreciate that. One of the things that I look at for candidate is the understanding of the impact, right? That decisions that you would make would have on the community, especially on youth who are most vulnerable, or who may be dealing with mental health concerns, who may be dealing with access to education, things of that nature. And so, in this role, it's important to be able to evaluate those cases. So I appreciate you taking the time to speak with me and to answer my questions, and I have further questions.
Thank you.
Thank you, Councilor Ziegler. Councilor Kennedy.
I've only got a couple of hours worth. Congratulations. Big deal. You've been a lawyer for 19 years?
But I thought it was more like 20, but
Well, you're going in your 20th year, you're in your 20th year, right? Right, and the first half of that, you weren't doing juvenile, right?
the first part of it.
Yeah, first
I
half.
was doing administrative law, correct?
Doing what?
Administrative law?
Yeah, so you've done juvenile work for about 10 years.
I would say more like 16. I got on the panel in 2008.
You started what in 2008?
That's when I signed up for the panel for CPCS, the Committee for Public Counsel, to take on Karen protection cases.
Because I'm looking at your resume. It says from 2008 to 2010, you worked for Richard Weiss.
Yes, and during,
Was doing bankruptcy, creditors' rights, things like that. You weren't doing.
correct, but I got on the panel during that time because he was in the middle of transitioning out. So I joined the panel, and while I was working with him, I started to go to the Suffolk court to try to take cases while I was working with him. He allowed that. But the way the cases were given back then, it just wasn't doable because you had to wait around to get a case. So then I stopped.
Understand that. I'm just curious why you didn't say that in your resume, that you did juvenile in there.
Yeah, I took the course then, but I didn't really get any cases because of the procedures of how it went. I couldn't wait
You didn't get any cases?
no, not during that
Judge
time.
Lawton didn't give you any cases?
During that time. Not the way the process was set up. You just had to wait.
He didn't yell at you, did he? He yelled at me a lot.
Remember, if it didn't hurt my feelings.
And I didn't even do juvenile and he yelled at me a lot. But no, I'm just curious, you're here becoming a juvenile court judge, and I was just looking over your resume, and it appears from your resume, you didn't start doing anything juvenile until 2010.
Until I opened my practice, that's when I started doing it full time, taking the cases, going back to Suffolk, waiting on the list and doing it. Just that actually, that's where I started off when most of the juvenile.
I would have, if it was me, I would have put that in that other section. If I was going, if I had 4 more years and the 6 more years, then your resume reflects if I was going for a juvenile court judge, but that's just me. So we know you've done a solid 10 years since you've been out on your own, and I like the fact that you've been out there on your own doing work. And let's talk about trials.
Sure.
How many trials? A lot of trials, that's good. If you can't count, that's a good sign. It's the people who know how many haven't done enough. Have you done a lot of jury trials in juvenile court?
No, not in juvenile court, no. Civil, not in juvenile court, no jury trials, because remember, I'm mostly on the care and protection side, so we don't have juries over there, it's just a jury.
Okay, so that most of your trials are care and protection. Have you done any delinquency trials?
No, because I haven't practiced on the delinquency side, I've only advocated on that side.
So you don't, so you have very, very little delinquency experience.
As far as representing clients before the juvenile court, correct.
Okay, that's okay. We need people who know how to do the other side too. And I asked the prior nominee this morning the same question. How are you gonna get up to speed on the delinquency stuff? Because you're gonna be doing a lot of that.
So again, speaking with my colleagues, doing CLEs, education courses. I know there's, some training when I get started. So just ongoing, I'm committed to learning.
Okay, that's good. Because you got a long way to go to get up to speed, because you're gonna be sitting on some pretty serious cases in juvenile court. They handle a lot of cases that in the adult court would be handled by a superior court, even if they're not youthful offenders, right?
Correct.
Okay, so you could be handling everything from, armed robberies to rapes, they used to do murders. I think all of them get indicted now, but directly indicted, but you're gonna be handling some pretty serious cases. Yeah, you got a long way to go to get up to speed.
Ready to get up to speed.
You ready for it?
Yeah.
Okay. Well, we had a long talk on the phone, twice, I think, yeah, twice. I think you called me Christmas Eve or something, and I said, it might not be a good time.
It was the day after Christmas.
I was out shopping, like every other guy, shopping on Christmas Eve for the wife. But but we did have a nice talk on the phone. We had a nice talk the other day on the phone. You answered all my questions. I'm very impressed with your demeanor more than anything else. I think you're gonna be super on the juvenile.
Thank you.
We'll for you next week.
Thank you, I appreciate that.
Thank you, Counselor. Counselor DePaula.
Thank you. Good afternoon.
Good afternoon.
Thank you for applying and congrats on your nomination.
Thank you.
I see that you have a lot of experience and we've heard it already and knowledge in psychology and trauma, the things that folks in the juvenile court are dealing with. And I know you've had experience in a lot of other areas, but there aren't a ton of lawyers who have 100% experience in juveniles. So I'm glad you applied and I'm glad the governor's office saw you appropriate to put you before the council. I want to ask you about dealing particularly with children. And as an attorney, as a judge, it's so hard to develop a relationship with a child who you're dealing with, who's in a sensitive spot, regardless of whether it's the middle of a care and protection or a CRA or whatever. It's so hard to gain their trust. Counselor I know is not here, but if he's listening, CRA is a child requiring assistance, formerly known as CHINS. How do you go about, because we want to tailor our outcomes to the best interest of the child. And so how do you get that information from, how do you know you're getting the information from the child? How can you get to a point where you feel confident that you know the full picture?
Well, I mean, in the juvenile court, care and protections, children are appointed an attorney. So that attorney is, representing the child, there's standards for them to be meeting with their clients for a certain amount of time and, meeting with collaterals and coming in and providing that information to the court. So, when we have, either motion statuses or pre-trials and, written documentation, I could be looking to see, what that attorney who's representing the child is writing on behalf of the child to get a idea of their viewpoint. Also, when care and protections are filed, judges, like you said, we can't go out and talk to the parties ourselves. So there's court investigators, which I am a court investigator or maybe was. So you go out and you talk to the children, then the court investigator does, and they are to talk directly to the child to, get their perspective on the case. So that's just there's a very ways of how I can get the information about how the child feels.
Yeah, but all those folks and the practitioners in particular, I mean, they're trying to chase kids down sometimes, right? It's hard to get a hold of children, or it's been my experience at times. Is that true?
I mean,
sometimes it's hard to communicate with your client.
It is. And
I know you're talking CMP, but in other matters that would be before juvenile court.
Yeah, so I mean, as with my representation, I represent a lot of children, in the juvenile court, and like you said, it is hard for them to warm up. It does take time. I have a child now that I represented since he was 5 and now he's 17. So it does take now he likes me.
Yeah, sure. It took a while.
It takes a while.
I just wonder, I mean, there's so many demands on this court and on the folks who practice there. And the best of intentions sometimes doesn't necessarily result in getting all the information from the child that you would want, that the attorney would want, that the judge would want. I'm just wondering, as a judge, how can you be sensitive to that? Like, how could you, is there something you would look for to recognize that there's more you need to know from the child's perspective?
Yeah, I mean, it just, it depends on, what case I have in front of me or what the issues are. But if I feel like there was more, I feel like since I've been doing this and representing children, depending on, what the issues are, and what's before me, I would ask questions if, for example, if you have a child who doesn't want to return home, or a child that does want to return home to their parent and they're, they were abused or neglected. Are they in therapy? Do they have services? Who are they, meeting with? So it's not just the attorney that you would get the information from. There are other sources, just so you can kind of, keep track on how the child's doing and if reunification, if that's the goal, if that's in their best interest.
And with all that input, you can kind of craft something that attempts to address underlying causes of why the child's before you, potentially, yeah. And you brought up, or it came up earlier in today's hearing, some of the disparate outcomes and some of the disparate impacts that happen across our court system and in some cases in juvenile courts. And I've seen that as well, often along the lines of race or class or developmental or learning disabilities. I've seen that a lot with kids coming through. And I'm wondering, And to set a premise for my question, I used to be a teacher and I taught in affluent districts and I taught in districts where families were facing complicated issues. And behavior from children in the affluent districts would never rise to the level of anything beyond gossip in school, and maybe they get grounded. And I had students who I would accompany to court who would face really substantial consequences for behavior because of where they were in the process, because they violated this condition or that condition that they shouldn't have done, and yet because of where they're at, the consequences I felt were disproportionate. And again, they're falling on the kids because of where they happen to be in the world. Have you ever seen conditions placed on a child that you thought were counterproductive? Have you handled any CRAs?
Yes, I used
Have you
to.
ever seen conditions that, in your estimation, in spite of everyone in the process having the best interest of the child at heart, have you ever seen conditions that you thought were counterproductive?
I mean, when I was representing the children requiring services, obviously as their attorney, we would go over the conditions, and they're minors, but still they're my clients. So I would make sure they understand what the conditions are, and they're not going to agree to something that they particularly cannot do. So if there is a question about it, then we would bring it back before the court to talk about that condition and maybe see if either that could be removed or something to that nature, just depending on the circumstances. Like if they had to, be home at a certain time. I mean, going to school every day for a child who's, already missing school, that could be.
Or facing risks at school, right? School isn't always a safe place. Group homes aren't always a safe place. Sometimes you flee a group home, not because you have ill intent, because you feel unsafe.
And if the child is not able, it's hard to get to know them right away. If they're not able to express that to you, that's something we have to work on. And again, do that look back to see, okay, when did this behavior start? And kind of what was the stressor? So we can try to figure it out and put in the best services or the best conditions.
As a former educator, I would find that school districts send administrative level people sometimes to CRA hearings. And they didn't really have firsthand knowledge of the kid beyond whatever superficial conversation that, again, the current attorney that was, for whatever reason, very recently appointed might have. But as a classroom teacher, I knew the kids very well. And I knew information that I knew the kids weren't sharing with the court that would have probably impacted things. And I was in a position where I was able to advocate for them because I did have that attorney background. And it just really concerned me. And I lost my train of thought, but I want to ask you one more thing. All the things we're talking about, I was thinking of a particular child. All the things we're talking about, and in your application throughout, you talk a lot about community resources, connecting families with resources that would be helpful, fostering collaborative partnerships with child welfare agencies, social service providers, etc. Do I infer from that properly that it's important that judges and practitioners and all these folks, all the members of the team, looking out for the best interests of the child, that it works better when folks are familiar with the immediate community they're serving?
If that's where that child is from, yes. If there's resources in the community that the child can, or the child or the family can have access to, it's good to collaborate and have that information. Because again, they want to get those services as soon as possible.
But it's important to have those relationships that exist, right? Because I would think over time, those relationships develop.
Yes.
Courtroom, right, between probation and social services. And
Correct. The people who can go out and have those collaborative conversations.
I think it's important we have regional people in the regions as well for just that reason. Can you think of, I'm sorry, do I have another minute? I've taken up my time.
1 minute.
Could you throw out an example of where having those community connections helped create a good outcome for a client or for a family or child?
Sure. I have a teenage client who, again, was slow to warm up, wasn't really buying into, the general terms of therapy, because, people have some stigma, or at least, kids do with therapy. So in that instance, we were able to reach out to an agency to get them what we call a life coach. So it's like a therapist, but it's a different name, and it's like a mentor, someone they can hang out with. And the kid was really, connected to this person quicker than other people. So they work with them, they were able to get a job and to help them with some other issues and concerns that they had at home. Because this this life coach was someone who was going into the home. They weren't just meeting with the kid. They would meet with the kid primarily, but they would also have weekly check-ins with the guardian.
Thank you for that. I appreciate all your answers. I'm really impressed with your perspective and your experience. And I have no further questions.
Thank you, Counselor.
Thank you.
Counselor Jacobs.
Thank you. It's good to see you. Thank you so much for figuring out a way in our schedules to come on out and give me time to really get to know you and discuss your background, but also a lot of issues around juvenile court. One of the things you highlighted several times in your application was the need for timeliness and efficiencies in the juvenile court. Can you speak to, I think in all of our courts, it's important that we're efficient and that we're, observing time standards, but in juvenile court particularly, I think it is such an important thing to focus and a priority around. Can you speak to your thoughts around, first off, what's the negative impact when there is delay? And secondly, if you have thoughts around how you might want to see processes improve or change, what you might be recommending.
Sure. I mean, the negative impact for when things are not, run smoothly or there's constant delays. A child, if they're out of the home, they're in care longer. And the goal is to, reunify children or have, children not be displaced or not have a permanency plan, unnecessarily. So that would be a delay if we're not doing things efficiently. I think we spoke about, there are, courts that I practice in where they do things efficiently. We'll have a 72-hour hearing, and at that hearing, we're going to get a motion status date and a pretrial date at the same time. I think that's efficient because you're keeping, the case moving and you're keeping things on track. I mean, the last result in those two scenarios is trial. So you kind of want to see how things go before you schedule a trial date way out, far out. But I think, keeping things close, keeping people accountable to the calendars and just not, wasting time picking dates back and forth so you can keep the case moving.
When children or teens are brought before the court under the label stubborn child, what does that mean?
It's under the formerly CHANS, now, child requiring services. It could be just a child who is having, issues responding to their parent at home, following the rules, going to school, acting out in some other way the parent felt, was not in their best interest. So they come to the court seeking assistance on, having that child correct that behavior.
What do you think about the word itself, using the word stubborn to identify situations like that?
I mean, I think it's, it's an old term, kids are stubborn, they could be stubborn, they could just be, there could be something else going on with them. So not necessarily stubborn. They could, there's a migraine of things that can go on, especially, after COVID with, children having anxiety. There's always something else behind the reason they're not doing the thing. So I think, again, it's important to identify that if you can by collecting the information and talking to their caregivers, because that's the only way you're going to be able to get them to hopefully be motivated to change their behavior.
That's a good segue into a hypothetical I wanted to put before you and get some response to. So in an instance where you have a teen, a high school aged student who is depressed, who isn't easily able to get out of bed, who has missed a couple of months worth of school, and a parental situation where there's economic distress and not a lot of access to resources, and a parent who really has no idea what to do. What approach would you take, and what what sort of a demeanor do you think would be best suited in handling things like that?
Well, you know, the child is, missing school, so I'm assuming the school has already filed a CRA. And it's come in to the court and, either the child is there or not, if the parent, can't get them there, because that's sometimes the case, so the parent is coming and advocating for the child. Again, just having resources for services. I know some schools, have resource officers and they literally go out to the home to try to talk to the child where they are. And try to, motivate them to come to school. I know that there's access to, services, therapy online now, so kids can have access to that where they physically can't get out of the bed. So, you have to start slow where they are. And, in my experience, from dealing with young people to dealing with my own children, you're not really going to motivate someone who is that unmotivated by having a demeanor that is, authoritative or forceful. It's gonna take time, unfortunately, and you just have to be patient with that time because there's something underlying going on. I mean, I think, some parents know their children best, and if they're really just, being disobedient, that's different. But nowadays, we see so many kids, suffering with trauma, even if they don't know why they're suffering with the trauma. But it's gonna take time to get to that. So I think having access to things that are virtual, basically meeting the child where they are and not taking an authoritative stance with them is a start to, trying to get them out of that situation or space.
I appreciate that. Do I have time for one more question?
Sure.
So what are your thoughts around what criteria you would use in holding a child / teen in contempt of court where they would be locked up, subject to a strip search type of a situation? What criteria would you use, and what is your if you could just share sort of your understanding of trauma pre a situation like that, and what if a teen were subjected to that or a child were subjected to that?
Yeah, I mean, I would, see that, as a last resort again. So just depending on, again, what is happening with this teen, what are the other factors? What are the conditions that they allegedly or did violate that gets them to that point? What's the seriousness, of the situation or the allegation to have that sort of response? I mean, I think that would be a last resort, but again, it depends, on the circumstances. If it's not violent, if they're not, harming themselves or others, I think there would be other ways to go about like disciplining that child. Again, keeping in mind and being informed of the trauma that they may have experienced that's causing them to have the behavior.
Can you speak more to that last part, trauma?
The trauma. Yeah, I mean, I've worked, with plenty of, children, youth, teenagers who are suffering through trauma. Sometimes it's not visible, again, it's out in the behavior. They're either not going to school, they're not talking, they're not eating. Just, kids who don't have trauma, it's hard to get more than one word out of them. So again, it's just the time, building that rapport, building the relationship, they have to feel comfortable. So you can try to assess what the underlying trauma or issue is.
That's all I have today, but thank you very much. Thank you.
Thank you.
Congratulations on your nomination.
Thank you.
I know that you said that your guidance counselor said it was unlikely for you to get into a college due to your grades. And that reminds me of myself. When I was in high school, my guidance counselor told me it's unlikely for me to get into a university. Look at you now, look at me now, right? So we know that judges have an immense amount of power and they can change the lives of a juvenile for the good and the bad. What steps would you make, given the power and the authority that you will have in your courtroom to give a juvenile a second chance once they enter into the criminal justice system for the first time?
Sure. I mean, as you know, with your that story and mine, words have power. Juveniles who, young people who are before you in the court, they're already there. It's already stressful. No one wants to really go to court. So I think it's the way, we address them, the way we communicate with them, the words we use. it's important, they're already there thinking it's negative, so it's important to use different language, to talk about something, positive that they may be doing, in order to not, have them, feel that this one moment in time is not gonna be something that's gonna be their future.
And we know prosecutors love the green sheet. Um, if a prosecutor comes to you and recommends, in a disposition recommends DYS, would you be willing to challenge them on the green sheet to give a recommendation for pretrial diversion?
I think I would, depending on the circumstances. Because that's, the goal is to keep kids out of detention, if it's possible. If it's possible, if we can keep them safe and keep the community safe, if there are other options in their community or other services they can do other than DYS, I would want to consider that first.
And given the fact that you worked with the DARE Family Services as a mentor, supervisor, and an outreach counselor, how do you believe those positions has helped you to be where you are today and prepare you for the next chapter in your life as a judge?
Sure. Well, working, doing the casework, and outreach services, I was, on the ground, working with the children, going into the schools, going to the IEP meeting, going to the basketball games, just doing all of the outreach wraparound things. And then when I became an attorney, when I first started out, I often forgot sometimes that I was the attorney because I was still doing those things, going to where the children were, helping them, navigate services, and do all the things that, the social worker is probably doing as well. So I think just having that one-on-one time, with the young students and children that I work with as a caseworker, representing children in care and protection, having, that relationship with them. Like I said, I have a client now who I've had since he was 5 and he's 17 now. So just having the relationship with them, being able to build that rapport. And yeah, I think that's what has helped me throughout. It's carried just that social service caseworker background to helping and representing children, get connected to services, to now, presiding over cases, being mindful that, the right services are being put in place for that particular child.
Thank you. And I know we had an opportunity to meet. It's wonderful to know that you've been practicing for at least 20 years or more, and that you raised 3 wonderful boys, right? As a mom, it's hard to do that now these days. And given the fact that you will have an opportunity to be in a setting where you'll be not only listening to cases that's dealing with juveniles, but an opportunity to make great change. And I thank you for coming out today and bringing your family and friends to support you. And again, congratulations on your nomination. Any other questions, counselors? Okay, meeting's adjourned.
He's gonna be.